5 seconds. PW7 HC Surinder Singh testified that on 17/04/2003, after autopsy on the corpse of Ranbir Singh, deceased, doctor handed over to him a parcel containing clothes of the deceased, one parcel containing viscera with an envelope duly sealed, and he handed over Sundar Sam those to Inspector Rajpal that were seized wide memo EXPH and 2013 09 06 15 53 I attached to the accuracy and integrity of this document. Punjab and Haryana High Court, Chandigarh, attested by him and others. Similar view was taken by the Honorable Supreme Court of India in Shambhunath Mehra versus State of Ajmer 1956 AIR SC 404 Sundar Sham 2013 96 1553 I attached to the accuracy and integrity of this document. Punjab and Haryana High Court, Chandigarh, wherein it was held that in a criminal case the burden of proof is on the prosecution and Section 106 of the Evidence Act is certainly not intended to relieve it of that duty. On the contrary, it is designed to meet certain exceptional cases in which it would be impossible or at any rate disproportionately difficult for the prosecution to establish facts which are especially within the knowledge or of the accused and which he could prove without difficulty or inconvenience. It was also held that Section 106 is an exception to Section 101 of the Evidence Act. It has been mentioned in Section 101 of the Evidence Act that whoever desires any court to give judgment as to any legal right or liability dependent on the existence of facts which he asserts must prove that those facts exist. Through the appellant has suffered extrajudicial confession before PW12 Ajit Singh, yet he has denied the same. At the same time, PW12 Ajit Singh, before whom the appellant suffered extrajudicial confession, was subjected to searching cross-examination by Sundar Sham, the learned counsel for the appellant, before the learned tried court. 2013 9 6 1553 I attached to the accuracy and integrity of this document. Punjab and Haryana High Court, Chandigarh, but long cross-examination failed to elect anything worth the name which could possibly cause any dent. From the testimony of PW12 Ajit Singh, it transpires that the appellant told him that on 15/04/2003 he and Ranveer Singh, deceased, had taken sugar cane from village Beoli for patron, and they sold the sugar cane at pattern and started their return journey for the village, and the appellant further disclosed that on the way they purchased a bottle of wine and reached village Sangatpura at the border of Punjab and Haryana, and from there appellant started driving the tractor and also started taking wine. He appellant further disclosed that he started driving the tractor at a fast speed, and on 1704-2003 they reached at Vishwakarma Chowk, Kaithal, and parked the tractor there for taking water when it was about 4 or 5 a.m. He further disclosed that after drinking water, Ranveer decaged started the tractor, and the appellant instead to drive the tractor himself, and in that process he gave a bottle blow on the side of the ear. As a result thereof it started bleeding, and Ranveer Singh decaged fell down on the ground. It has been held in the judgment supra that after order of conviction it is mandatory duty of the court to consider the question of award of compensation to victim of crime. However, it is discretion. Sundar Syam 2013 9 6 1553. I attest to the accuracy and integrity of this document. Punjab and Haryana High Court, Chandigarh of court to award or not to award compensation. It was also held that the capacity of the accused to pay compensation would involve certain inquiry, albeit summary,